All right, welcome everyone. Thanks for tuning in. It is another Friday, so that means free webinar Friday. Thanks to everyone that's been tuning in. I've been enjoying doing these streams. Last week we had our other attorneys on as well. We had Will Graves and Anna Wheeler with us. Today I'll be speaking about what happens to a trust and an estate after someone passes away. So thanks everyone for tuning in. My name is Rilus Dana. I'm an attorney here at Dana & Associates Law Firm. We practice in Arizona and California. Our physical offices are located in Mesa, Chandler, Scottsdale, and Payson, Arizona. And then we have a virtual office in Encinitas, California. So we're seeing clients there virtually. And we're seeing all clients right now virtually. Hopefully we'll have them back in our office soon. But it's been nice that we can still practice virtually with the video meetings, and now with the remote notary, it's really changing the game. So our processes are going to be updating a little bit more. So thanks to everyone tuning in. If you have any questions, put them up on, leave a comment, let us know what you tuned in today for. If you had a specific question today that you would like the answer to, leave it in the comments and I'll try to get to it. So today the topic I want to focus on is what happens. So the question I get a lot, sometimes this is from people that are doing their own plan and they name their kids as the trustees, and they ask, what do they need to do? What happens after we're gone? What happens at that point? So this is probably something I'll be doing regularly. This will be a regular theme, how to administer a trust and an estate. So people can tune in to get their questions asked, and I'll give a general overview of what happens in that process. So let me share my screen here. Okay, so there's my screen there. Let me control it. Let's try this. Actually, let's try this view. Okay, so all right, so this is the presentation that we use when we meet in our first meeting, which we call the personal family legal session, or now we're calling it the virtual family legal session. So if you'd like to get your own estate plan created, give us a call, a text, or an email. I put the numbers on the screen below, so you can reach out to us to schedule a time for your meeting. Now, during that meeting, what we'll do, we'll send you a short personal inventory to fill out before. It's only 2 pages. I've seen some attorneys, sometimes these are 10, 15 pages long, but we're trying to make it easy for you. So we'll send you just a 2-page personal inventory to fill out, tells who you are. And then I'll ask, what was it that led you to schedule this meeting? And depending on what that question is, I'll come into this presentation at the right part. And let's start here. Let's talk about probate. So this is why a lot of people do their estate planning, is to avoid probate. Now, probate's one of those things that not too many people know what it is until it's too late. So what is probate? So here's our friends. This is Mrs. Estate, and she has a house, and she's married to Mr. Estate. They're the star of our videos, Mr. and Mrs. Estate. I should have come up with a better name in the beginning, but that's it. We just have Mr. Estate and Mrs. Estate. So they own a house together. She has a bank account in her name, and she has a life insurance policy that names Mr. Estate as the beneficiary. So after she passes away, the life insurance will transfer to him. So will the house. But how does he collect this bank account? So in order to collect this bank account, what he'll do is, if she has a will, that'll be controlling. In this case, she does have a last will and testament. If she didn't have a will, then we would look at what's called the laws of intestacy. That's the default order of who gets your stuff if you don't have a will. So probate, it's the process to appoint a personal representative. So this green hat, this visor, this is an accounting bookkeeper visor, or that's what it's symbolizing. and the beneficiaries. So probate determines who's in charge and who's the beneficiaries of the estate. There's Uncle Sam there. Once you go through the steps and file the probate with the court, they'll appoint the personal representative and give them the authority to manage the estate. So what to do after mom and dad pass away? If there's an account in just one of their names, then a probate could be necessary to get the authority. Now, there's lots of steps to probate, and it takes a long time. That's why we like to avoid probate, especially in Arizona and California. The probate's very expensive and time-consuming. That's my understanding. Some of these Midwest states and back east, everyone goes through probate, and it's not that big of a deal. But out here, Arizona, California, we like to avoid probate because it's time-consuming and can be expensive. So eventually, he's able to collect that account after he goes through all the steps of the probate. All right, now let's get into what a trust is. So if mom and dad have a trust and there's assets inside of a trust, let's look at how that works. And the focus of today is what happens after they pass away. So let me show a different video. I'm not showing what a trust is. And let's go through, let's go through the new sub trust video. Let's see if I even remember this. I created this last Friday, shot a bunch of videos on it. And those are going to be released soon. This week, they'll be on the Mott Legal YouTube channel. Just met with Bobby today, our video guy, and saw drafts of a bunch of those. So subtrust. So what is a subtrust? So a subtrust is the trust that your parents' trust creates. So here's Mr. and Mrs. Estate. They're the trustors of this trust. And after they pass away, we'll determine who the beneficiaries are, who's in charge as the trustee, and the subtrust is the conditions that are controlling. So we need to look at what are the conditions in the trust after the trust creators pass away. So that this age trust is showing that beneficiaries under the age of 30 will have their share held by the trustee, and then they get 1/3 at age 20, half at 25, and then the balance at age 30. That's one of the most common subtrusts. There's also a special needs trust. This is for beneficiaries that are on government benefits, needs-based benefits. So if they receive their inheritance outright in their name, they'll be disqualified from the benefits. So for those special needs beneficiaries, we hold their share in trust to supplement them and not supplant or replace the public benefits. Another type of subtrust is what we call a dynasty trust. Generation skipping trust is the tax terms for all you tax nerds out there. Dynasty trust. So what this is a trust where it's designed to continue from generation to generation. So we use the word dynasty trust. It's commonly called dynasty trust by estate planners. Dynasty, where you're creating a legacy, something that's going to live on far beyond you, hopefully. So with the dynasty trust, it's held at the trustee discretion for the benefit of the beneficiaries. They have a power of appointment. So each beneficiary, there's also a pet trust is another type of subtrust. So let's go through, let me show you how this dynasty trust works. So let's go back. So sorry, I'm kind of all over the place. So today's topic is what happens after mom and dad pass away. So what you need to do is, if they have a trust, we want to see what's inside of that trust and what are the terms of the trust, what types of subtrust. If they don't have a trust, then we need to see what's controlling their assets. Okay, let's go through. Let's go through this dynasty trust. Show you how that works. So the way the dynasty trust works is that each beneficiary will receive their own dynasty trust. So in this case, there's 3 beneficiaries. The dynasty trust allows them to become the trustee at age 35. So this trustee would be appointed over here to manage it for the benefit of these beneficiaries over here until they reach the age of 35. Now, upon the age of 35, this oldest child, what's going to happen? He's going to become the trustee. So his inheritance will still stay inside of this trust, which is separate from him. And that's what gives him asset protection. So if he got into a car accident and was sued or got divorced, whatever assets are inside of this trust are separate from him. So that gives him protection. All right, so that's the way the dynasty trust works. So you'll want to see if there's a trust, you'll need to see which type of subtrust there is. What are the conditions and who are the beneficiaries? Let me go through this other scenario. So this shows, let's show this, a continuation trust. So Mr. and Mrs. Estate, a house, a bank account, 2 IRAs. What do those look like to you guys? What do you think these IRA pictures are to you? I had some people this morning, they said, what do you use pill bottles for the IRAs? And those are actually, or at least I thought they were like piggy banks, like jars of money, or maybe pill jars, if that's what you see. Life insurance. Okay, so Mr. and Mrs. Estate, they create a trust. They do an age restriction trust for their beneficiaries as a subtrust. They designate their trustees. They're the trustors of the trust, the creators of the trust, the trustees that manage it, and they're the beneficiaries that benefit from the trust. The trust is revocable while they're alive because they have the power to change it. So it's revocable. They'll transfer their house into the trust, their bank accounts into the trust. The IRAs stay out, but they'll name beneficiaries of them. And same thing with the life insurance. We're not going to transfer the ownership into their trust, but they'll name beneficiaries. Okay, so Mr. Estate passes away. Mrs. Estate, she maintains her life insurance. And his life insurance, we look to see who the beneficiary is, which is the trust. So those proceeds will get added to the trust bank account, which Mrs. Estate still controls as the trustor. She's the trustee, so she manages it. And she's the beneficiary, so she's the only one entitled to receive anything from the trust. The trust is still revocable because she has the power to change it. And then she rolls over his IRA into her IRA. Okay. So time goes on. Mrs. Estate, she gets dementia. She's unable to manage the trust for herself. So a new trustee gets appointed. Okay, so in this example, Mrs. Estate's still alive, but she passes her trustee hat to someone else. We call this a living trust administration. So living, because Mrs. Estate's still living and she's still the beneficiary, the administration refers to the work that needs to be done to pass this hat. So in order to pass this hat over to the trustee, Mrs. Estate needs to resign as trustee or appoint him. So sometimes this is voluntary. If she still has the capacity, she could sign a document that names someone else as the trustee. Or if she no longer has capacity due to a health condition, we use the standard in our documents of 2 doctors' letters. So if 2 doctors say that she's unable to handle her affairs, that's when the successor trustee gets to step in. Now, for the successor trustee to step in, they have to prove that they have the authority. So we prepare a document that we call the acceptance of trustee. That's what shows that this trustee has the authority to act for the name of the trust. Now, in this situation, the trustee, his boss, is the trustor. She's the beneficiary. So he's managing the assets inside of the trust for her benefit as the beneficiary of the trust. Now, whenever a trustee is appointed, there's some things that need to be done. So number one is you have to give notice to the beneficiaries. Arizona Trust Code, California Trust Code, they both provide that when the trustee is appointed, then they have to give notice to all the beneficiaries. Now, the Arizona Trust Code, what it says is that all qualified beneficiaries should receive notice. So what is a qualified beneficiary? A qualified beneficiary, according to the Arizona Trust Code, is the beneficiaries that would receive something in the event the present beneficiary passed away. So those are the qualified beneficiaries. So when this torch or this hat was passed to the trustee, he should give notice to all the other beneficiaries of the trust so that they know he is serving as a trustee. Now, after Mrs. Estate passes away, at that time, the trust becomes irrevocable. No one can change it. While she was alive, she has the power to change it technically, even though she's not the trustee. After she's gone and passed away, the trust is locked at that time. No one can change her wishes. Okay, so the trustee at this point, so if she just passed away, then the trustee oftentimes isn't appointed yet. We need, as part of the administration, we need to appoint the trustee. So whenever you appoint the trustee, you got to give notice to all the beneficiaries. Now, even if he was appointed while Mrs. Estate was alive, after she passed away, we would give notice again to all the beneficiaries. Let them know that, hey, she passed away. This is the trustee, and here's his contact information where you can reach him. For the trustees that hire our office, they hire us to help them in this service. We use our address and our contact information. So that way, if the beneficiaries are reaching out to them, it goes directly to our office. Okay, so earlier I said you got to determine what's in the trust, what assets are in the trust, and what assets are outside of the trust. So this is showing there's a house owned by a trust and also a bank account owned by the trust. And then there's an IRA outside of the trust. So the IRA is controlled by the beneficiaries that are named. So these hands down here, this is symbolizing the beneficiaries that are named with that contract. So if the IRA is at Fidelity and then it names these people to receive it, that's going to be controlling. Okay, oops, I'm going backwards. Okay, so here's the beneficiaries of the IRA. And the proceeds from the IRA are subject to income tax. And then that will be divided to those beneficiaries. So that's outside of the trust. And life insurance. So again, we got to look to see who the beneficiary is. Proceeds from life insurance are income tax free. The trust was the beneficiary, so that gets added to those accounts. All right, so the job as a trustee, there's a lot of liability to this job. So the trustee has a fiduciary duty. So this green visor, whether it's a trustee or we saw it earlier as a personal representative under the will, this is the fiduciary. So what a fiduciary is, that's someone who's managing money for the benefit of another. So whenever you're managing money for the benefit of another, you're held to a higher standard. So that's probably the biggest job as the trustee. So whatever is inside of the trust, whatever assets there are, the trustee has a duty to make best use of that asset. Now, what is that? So well, that depends. Depends on the ages of these beneficiaries and the types of assets in the trust. So people will ask me, well, the trustees, they'll say, what should I do? Should I, there might be stocks and investments like that. They say, what should I do? Should I liquidate everything and turn it into cash? Maybe that could be good, depending on the beneficiaries. Or there could be a bunch of cash And the trustee will say, what should I do? Do I need to invest this? And again, I'll say maybe, depending on the ages and needs of the beneficiaries. What my legal advice is that they hire a financial advisor, because they have a duty to do what's best for these assets. Unless they're an expert, it's best to get some help in that area to decide what is the best way to manage those. For the house, that's often a decision that the trustee has to make, what to do with the house. Do they sell it? Do they keep it? Okay, the terms of the trust. This trust is an age restriction trust where it holds it until the beneficiaries turn 30. We're calling that an age trust. So they get 1/3 at age 20, half at 25, and the balance at age 30. The 33, 21, and 18. So this scenario, the trustee decided that the house should be sold, and added to the trust bank account. And the oldest beneficiary over 33, who's also the trustee, yeah, they do look similar. And that is common, that the oldest child or one of the children does serve as the trustee. So he gets his share. And then for the other two beneficiary, a trust will be created for them. The trustee he'll have to get another tax ID number in the name of this trust. We'll do what we call an acceptance of trustee, show that the trustee has the authority to open this bank account, give him the tools that he needs to walk into the bank and open up a bank account in the name of this trust. And for this 21-year-old beneficiary, so he gets 1/3 directly, and then the rest of his share is held in his trust. For this 18-year-old beneficiary, all of her share will be held in trust. So another acceptance of trustee showing that the trustee is in charge of this account. Another tax ID number, so you can go to the bank and open a bank account in the name of this trust. Now the trustee, he'll continue to manage these trusts until the beneficiaries reach the age of 30. And then eventually it'll be wound down completely. So yeah, that's one of the most common questions I get, or I guess I get a lot of different common questions. But I wanted to share what the trustees need to do after the parents pass away. So break that down, go back. Okay, so once this trustee is appointed, there's some work that needs to be done to get him appointed to show that he has the authority over those accounts. Reporting to all the beneficiaries. And then it's his job to figure out what all the assets are and what the best use is to manage those. So I hope you found this information helpful. I hope you guys have been enjoying these live streams. If there's any other topics you'd like to hear about, let us know. Leave a comment, send us an email. Love to discuss it on the stream. Yeah, so the banner going below, it's talking about what we call our virtual personal family legal session. That's the meeting to create your own plan. Now, if you're worried about your parents' plan, or maybe you're named as the trustee or the personal representative for your parents, we can help you with that as well. We call those meetings a family administration session. So that's where we'll meet with you as the trustee, go over your job and responsibility, and depending on what it depends on, the fee, it depends on the number of beneficiaries and the types of assets. So it could be a large estate, but if it's a single bank account going to single beneficiary, that's pretty easy. And again, it could be a smaller estate, but if it's being split between 12 people and in 5 different types of sub trust, that's going to take a little bit more time to deal with all of those beneficiaries. So an important since we do the administration process, since we help families after someone passes away, this helps us to be better planners because we're mindful of what it takes to administer an estate and a trust. So sometimes I see what people think are a good idea, and it's unnecessary administration. For example, if they have a trust that says give 1% to each of my 25 grandkids, that's hard because we got 25 different people we have to deal with, and that's 25 people that we have to give an accounting to show them what 1% of the estate is. That's 25 people that could lawyer up and decide that it should have been administered differently. And then depending what the amount is. Now, if it's a $25 million estate, that'd be a significant amount, 1%. But if it was a $200,000 estate, it can be where the cost to locate each beneficiary is more than the actual gift itself. So something to be considerate of. All right, we got a question here from Jeff. Thanks for tuning in. Can I buy the house before the probate process is completely done? Great question, Jeff. Yes, you can. Good. So let's talk about the timing of the probate. So probate, let me go back to my little diagram here. So probate, once the personal representative is appointed by the estate or is appointed from the probate court. All right, so this example, all right, he's trying to get this bank account. She's got a will. So as soon as he gets appointed by the probate court, and I'm showing that hat sliding on is Mr. Estate being appointed by the probate court. At this time, he has the authority to sell the assets in the estate. Now, that means, so if he sells the house, then he'll have cash, which he'll report as an asset of the estate. So great question, Jeff. And that's something that I emphasize a lot to the investors. I work with a lot of different real estate investors. People are watching on Pace's channel. Thanks for tuning in. But yeah, I want to emphasize how long it takes until they have the authority to sell the property. In Arizona, it takes us about 6 to 8 weeks in total to get someone the authority to sell the property. So what that is, so once someone hires us for the probate, it takes us about 3 to 4 weeks to prepare what we call the first wave of paperwork, everything that we need to file to open the probate. And then it sits at court for another 3 to 6 weeks until the judge stamps it and approves it. After he approves it, that's when the personal representative is appointed. And that process, what I'm describing, that's what's called an informal probate. So informal, that means that no one's challenging, everyone agrees to it, and we have the original will to file. If we don't have the original will, then we have to go what's called a formal probate. We have to request a hearing and show, give everyone notice. And then if we have a copy of the will that we're trying to admit or something else, we have a hearing and the judge decides whether to probate the copy of the will or how to proceed. Let's see, another question from Jeff. Can the bank attorney intervene? I had one complicate a deal. Yeah, bank attorneys, now there's the law and then there's bank policy. So I fight with banks all the time. I tell them what the law is and they tell me what their policy is. What state was that in, Jeff? I don't know why the bank attorney would be involved unless there was there a foreclosure going on? That would give the bank some rights, possibly, if they were foreclosing on it. But usually the bank attorney doesn't deal with it. It's a personal representative of the estate gets appointed, and then they have a duty to liquidate the assets of the estate. But yeah, those banks can make things complicated. Great questions, though. Thanks for the questions, Jeff. Thanks for watching. Timing of probate. It takes a while. The whole process is just lengthy. Average time is probably, I don't know, about 9 months, I would guess. Yeah, the average is. In Arizona, there's there's built-in waiting period. So after we get the personal representative appointed, you have to post in the newspaper to give any creditors notice and then wait for 4 months. So regardless, so it takes, I said, the first 6 to 8 weeks to get the personal representative appointed. As soon as they're appointed, then we'll file in the newspaper, start the 4-month period. So it could be as quick as maybe 5 months, but it's usually around 9 months or so to wrap up the whole thing. So, all right. So that was in Oklahoma, in a small town. Yes, they're late on the payments. Yes, small towns can change things as well. I practice in Payson, Arizona, which is a small town about an hour north of the valley here, an hour north of Phoenix. Beautiful place, but a little bit different in the small towns. Things can be a little bit different. I saw a small town situation in Payson where after someone passed away, the bank accelerated the due on sale clause. That was one of the very few times that I've seen an acceleration clause actually activated. I know people worry about them a lot, mostly unnecessary, but that was one of the few times I saw it activated. But I think it was someone in the town wanted the property. So that's what was happening. It was some small town politics going on where they accelerated they called the note due just in an attempt to try to get the real estate, I think. So, all right, guys. Well, I think I'm going to wrap it up now. I appreciate everyone tuning in. And like I said, if you have any specific questions you'd like to hear about, leave a comment and we'll talk about it next week. See another question from Jeff. How many times do you have to post in newspaper? I think the bank attorney had a relationship with another investor and the bank attorney was listed as a rep on the probate docket. Okay. So it's going to be different in every state. So in Arizona, we just post once, and then I think not once. I think it's 4 different times actually is what we have to do. Luckily, I don't know it. I have a great paralegal, Lori, probate and administration paralegal. She handles all of that, all the details. I know it's always a lot of hurry up and wait. We're hurrying to file the probate, and then we wait for the judge to approve it. And then after it's approved, we hurry and file in the newspaper and then wait for that 4-month creditor period. But I think you have to do it 4 times in Arizona. Now, it sounds like your situation, Jeff, maybe the banker was listed as a personal representative. So if they were listed as a personal representative, they're the ones that have the authority over the estate. That's interesting. Maybe they were listed because of the probate. Maybe they had an interest in the estate for that reason. So not sure how they do it in Oklahoma. So I just worry about Arizona, California. I'm licensed in Nevada too, but I don't really practice there. I'm currently inactive in Nevada. It's enough focusing on just the 2 states, Arizona, California. Luckily, their laws are pretty similar. I would say that Arizona kind of copied California, but it seems lately, I would say the Arizona laws are more progressive than California. Arizona, we had the digital RUFADA, Revised Uniform Fiduciary Access to Digital Asset Act. That was passed in 2016 in Arizona, not till 2017 in California. Decanting, which allows you to non-judicially change an irrevocable trust without the court. We had that in Arizona before California. Arizona, you can now do electronic wills, although I don't like them. You can do them. California doesn't have that. I don't believe they have it. Remote online notary, we got that in Arizona, effective. It started April 10th. It was sped up by Corona. California doesn't have that either. So it's nice to see how Arizona is a progressive state in some of the laws. And a cool thing about practicing in multiple states is I get to compare the different laws in different places. So I get the news from 3 different states, from 3 different bars, and I can see what's happening in the different places and then copy and adapt what I like best. So thanks everyone for tuning in. Hope you have a great week, great weekend, and we'll see you next week.